Mr. Crowe.
May it please you, my lady. I appear with Mr. Bell of Walkers and with Mr. Lilly of Counsel for the Maso parties, Mr. Jones, Queen's Counsel, with Mr. Mann and Ms. Park of Harneys for Shanda. As you are aware, I'm sure there are two appeals. One is concerned with the question whether or not the Court of Appeal in the Cayman Islands was correct in applying a discount to the valuation of my client's shares. And the second appeal, which is my learned friend's appeal, is concerned with the question whether the Court of Appeal was correct in upholding the trial judge's ruling on the fair rate of interest. We apprehend, and you will probably have gathered just from the length of the written cases, that we will be spending far longer on minority discount than we will on fair interest. And subject to your lordships, my lady, the timetable it has been agreed between counsel such that I should be sitting down at about noon. Although if I overrun that, I apprehend I will obviously need to shade off my reply, but I should be sitting down around noon. My learned friend will then reply on minority discount and open on his fair interest appeal until about 3 o'clock, giving me 5 minutes short of an hour to close on minority discount and reply on interest, and my learned friend approximately 5 minutes if he needs on the fair interest point. So if I could start straight with the minority discount issue, and to state the obvious, although perhaps worth stating, it is a point of statutory interpretation, and it is an extremely narrow point. Could I just invite your attention to the statement of facts and issues, paragraph 23.1. If you're on the electronic bundle, I believe you'll find it on page 2014. It's the very last page of the statement of facts and issues. You will see from paragraph 23.1 where we have identified the issue in relation to minority discount. The question is whether or not the Court of Appeal of the Cayman Islands was correct in holding that a minority discount should be applied in the determination of the fair value of the Maso party's shares pursuant to section 238 of the company's law. So the only issue is whether a minority discount should be applied. This is not, if I can emphasize, this is not an appeal about the valuation of the company as a whole. I merely mention that because some of the observations in my learned friend's written case do appear to drift into questions of valuation of the company. And we simply open by urging all of you to answer the question as posed, and not to be tempted to drift into other matters which have not been argued and which have not arisen for determination. It is the fact that Section 238 has generated a considerable amount of litigation. There is much more coming through the pipeline, and it would be undesirable with respect for passing remarks to be made on issues that do not arise. So we do, with the greatest respect, invite your lordships and my lady to focus only on the issue as stated. And to put it
I'm not sure if I may interrupt just a moment. I'm not sure that perhaps every member of the panel was aware of the fact, but we did have an application to intervene from another much larger case than this even, which is on its way, and we have declined that, but obviously we'll be careful as to how far we express any views about the interpretation of the section.
I'm very grateful. To put it in slightly crude lay terms, the valuation of the company itself has not been appealed. So essentially, we know how big the cake is. The issue in relation to our appeal is purely a question of whether my clients are entitled to a proportionate slice of that cake by reference to the number of shares they hold, or whether their valuation should be reduced by a discount to reflect the fact that my clients hold a minority interest. The answer to that, we would suggest, may be approached best by starting with a very brief look at what a minority discount is intended to reflect. And for that purpose, if we could go in the authorities bundle, volume 7 at tab 76, or if you are purely electronic, page 4001. Tab 76 should be a Court of Appeal decision in the case of Strahan and Wilcock. Just for the purpose of getting our heads in the right place as to what a minority discount reflects, without going to any of the facts, I just wanted to draw your attention to paragraph 1 in the judgment of Lady Justice Arden, as she then was, which sets out the issue in that case. This was an unfair prejudice case as to whether or not there had been unfair prejudice, and if so, what the appropriate remedy should be. And if we look between letters F and G, right towards the end of the line, there's a sentence beginning, "In these circumstances, should the principal shareholder purchase the shares of the new participant, and if so, should he do so on terms that the new participant receives the full value of the shares, i.e. their non-discounted value, or should those shares be valued on the basis that they represent a minority shareholding, i.e. on terms that their value is discounted to reflect their non-saleability in the open market?" So what we derive from that is essentially that the concept of a minority discount reflects the non-marketability or limited marketability of a minority shareholding. And so, in other words, it reflects the fact that in general, a prospective purchaser of those shares will be less interested in acquiring a minority holding and hence will pay less for it. So it is a concept that is concerned with assessing the value to a seller of a minority shareholding by reference to the purchase price which a buyer in normal market conditions would be willing to pay. And that being the rationale of the underlying principle of what a minority discount actually is, we would ask you to bear that in mind when we turn to the legislation, which I would now like to do in volume 1 of the authorities bundle at tab 8, or page 2213 if you are electronic. Oh, sorry, actually, tab 6, I do apologise. Volume 1, tab 6, page 2160 to start. This is extracts from the Cayman Islands Companies Law. We're using the 2013 revision because that is the applicable regime for the purposes of this case. I don't think any of the legislation has changed in any relevant degree since then, but just to be absolutely sure we're using the applicable revision. And I just wanted to start by taking you to sections 86 and 88, which are not directly in point, but the fact that they're there, the terms in which they're drafted, and in particular the differences between them and section 238 will become more apparent as we look at some of the case law which the Court of Appeal took into account. So I just want to start taking it in sequence with section 86, which is on page 2176 electronically, which is dealing with essentially schemes of arrangement. So where a company wishes to rearrange or reconstruct itself, provision is made for the mechanics for achieving that outcome. So section 86 provides where a compromise or arrangement is proposed between a company and its creditors or any class of them, or between the company and its members or any class of them, the court may, on the application of the company or of any creditor or member of the company, or where a company is being wound up of the liquidator, order a meeting of the creditors or class of creditors or the members of the company or class of members, as the case may be, to be summoned in such manner as the court directs. And then subsection 2 provides that if a majority in number representing 75% in value of the creditors or class of creditors or members of, or class of members present and voting agree to any compromise or arrangement, the compromise or arrangement shall, if sanctioned by the court, be binding on all the creditors of all the class of creditors, or the members or class of members, as the case may be. So essentially, for a scheme of arrangement under Cayman law, the two features we would ask you to bear in mind are, first of all, the percentage required for shareholder approval, which is 75%. Secondly, that separate class meetings can be ordered to represent different interest groups. And thirdly, that even where the statutory majority has been achieved, what is required is court sanction. And I just ask you to hold those three thoughts in mind before we get on to the case law. Section 88 is the next one, page 2178. Section 88 it has been referred to as the squeeze-out provision, which operates in the context of takeovers, and the regime here is somewhat different. I was taking you through 88 subsection 1, where a scheme or contract involving the transfer of shares or any class of shares in a company to another company, whether a company within the meaning of this law or not, has within 4 months after the making of the offer in that behalf by the transferee company been approved by the holders of not less than 90% in value of the shares affected, the transferee company may, at any time within 2 months after the expiration of the said 4 months, give notice in the prescribed manner to any dissenting shareholder that it desires to acquire his shares. And where such notice is given, the transferee company shall, unless on an application made by the dissenting shareholder within 1 month from the date on which the notice is given, the court thinks fit to order otherwise, be entitled and bound to acquire those shares on the terms on which, under the scheme or contract, the shares of the approving shareholders are to be transferred to the transferee company. So the thoughts that we would just ask you to bear in mind before we get to the case law are that the statutory majority here is 90%. Second, that the obligation is to buy at the offer price, which has been accepted by the statutory majority. Thirdly, unless the court thinks fit to make a different order. So there is essentially a sort of starting presumption that the 90% know best, so to speak, but the court then has a discretion to make some different order. I simply take you to those because the Court of Appeal in our case was, in our submission, wrongly distracted by looking at some English case law on comparable provisions. And I just want to get those points in your minds before we start. Then turning to the relevant sections of the legislation to dealing with mergers and consolidation, we move on to tab 8 in the same bundle, page 2215 electronically. The first section, 232, is a definitions section, and it explains the terms used. So essentially, just putting it very shortly, merger is where you have two or more constituent companies, as they are called, and their assets, undertakings, business are merged into one of them, such that that surviving company has the merged business of both of them. And a consolidation arises when you have two or more constituent companies whose entire assets and undertaking are merged into a new company, which is called the consolidated company. So they are simply different structures for achieving essentially the same economic outcome, which is a complete combination of all the assets and undertakings of two or more entities. And then section 233 then provides, without prejudice to 86 and 87, but subject to 239A, two or more companies limited by shares and incorporated under this law may, subject to any express provisions to the contrary in the Mem and Articles of Association, merge or consolidate in accordance with subsections 3 to 15. And then subsection 2 doesn't apply, that deals with various regulatory provisions. Over the page, subsection 3, the directors of each constituent company that proposes to participate in a merger or consolidation shall, on behalf of the constituent company of which they are directors, approve a written plan of merger or consolidation, and then subsection 4 sets out what the plan must include. And then if we go on to subsection 6, a plan or merger a plan of merger or consolidation shall be authorized by each constituent company by way of a special resolution. Now, for these purposes, I won't take you back to it, but under section 60 of the Act, which is at page 2168 if you want it, a special resolution here is a 2/3 majority. So the plan has to be authorized by a 2/3 majority, and such other authorization, if any, as may be specified in the company's Articles of Association. And then I think we can move on to subsection 11, which is page 2218. Upon payment of the applicable fees under this law and upon the registrar being satisfied that the requirements of subsection 9 in respect to the merger have been complied with, the registrar shall register the plan of merger or consolidation, including any new or amended mem and arts, and issue a certificate of merger. Subsection 13, subject to section 234, a merger or consolidation shall be effective on the date the plan of merger or consolidation is registered by the registrar. And then, just to complete the mechanics, so to speak, section 236 over the page on 2219, as soon as a merger or consolidation becomes effective, in the case of consolidation, the new mem and arts filed with the plan shall immediately become the mem and arts of the consolidated company. B, importantly, the rights, the property of every description, including shows in action and the business, undertaking, goodwill, benefits, immunities, and privileges of each of the constituent companies shall immediately vest in the surviving or consolidated company. And then subsection 3, upon a merger or consolidation becoming effective, the registrar shall strike off a constituent company that is not the surviving company, or a constituent company that participates in the consolidation, section 158 shall apply. So the features, in contrast with the schemes of arrangement that we've seen, which required 75% and court sanction, and the squeeze-out provisions in a takeover, which we have seen, which required 90% acceptance, and then an opportunity to buy at the offer price. The features that you will see of the Cayman merger and consolidation regime are that no court sanction is required and a mere 2/3 majority is sufficient. But there is a quid pro quo to allowing companies that liberty to merge with such a modest majority, and the quid pro quo appears in section 238, which is page 2225. And this is obviously the section with which we are concerned, so I'll just take a little bit of time to identify the relevant features of it. 238 subsection 1, a member of a constituent company incorporated under this law shall be entitled to payment of the fair value of his shares upon dissenting from a merger or consolidation. So it is not a matter of discretion or of invoking the court's goodwill. It is an entitlement, and it's an entitlement to the fair value. So there is both an absolute entitlement and there is a definition of what the entitlement triggers. 2, a member who desires to exercise his entitlement under subsection 1 shall give to the constituent company before the vote on the merger or consolidation written objection to the action. So there's a formal requirement, if you want to dissent, to trigger the rights under this by serving a notice of objection. An objection under subsection 2 shall include a statement that the member proposes to demand payment for his shares if the merger or consolidation is authorised by vote. So if you are objecting to the terms of the merger, the statute tells you what you are entitled to ask for. It's not, you're not invoking a discretionary remedy from the court. You can't choose a different outcome. The statute tells you the outcome that your notice has to seek. And then the mechanics continue. Subsection 4, within 20 days immediately following the date on which the vote of members giving authorisation for the merger or consolidation is made, the constituent company shall give written notice of the authorisation to each member who made a written objection. And then subsection 5, a member who elects to dissent shall, within 20 days immediately following the date on which the notice received in 4 is given, give the constituent company a written notice of his decision to dissent, and then details of names and address and so on. Subsection 6 requires one to dissent in respect of all shares. You can't be selective about it. Subsection 7, upon giving a notice of dissent under subsection 5, the member to whom the notice relates shall cease to have any rights of a member except the right to be paid, fair value of his shares, and the rights referred to in 12 and 16. So essentially, the relationship of shareholder and company at that point ends, and there is purely the operation of the statutory mechanism for assessment and payment of fair value. And then subsection 8 is important because what it encourages is an absence of litigation if possible. What it encourages is the dissenters and the company to try agreeing what the fair value is. So there's an express statutory stage that has to be gone through within 7 days, immediately following the date of the expiration of the period specified in 5, or within 7 days immediately following the date on which a plan of merger or consolidation is filed, whichever is later. The constituent company, the surviving company or the consolidated company, shall make a written offer to each dissenting member to purchase his shares at a specified price that the company determines to be their fair value. And if within 30 days immediately following the date on which the offer is made, the company making the offer and the dissenting member agree upon the price to be paid for his shares, the company shall pay to the member the amount in money forthwith. So step 1, try to agree. Don't trouble the court. Subsection 9, over the page, if the company and dissenting member fail within the period specified to agree on the price to be paid, within 20 days immediately following the date on which the period expires, the company shall, and the dissenting member may, file a petition with the court for a determination of the fair value of the shares of all dissenting members. So what is procedurally important is that the requirement, the express requirement of the legislation, is that the company has to initiate the process for assessing fair value. This is entirely unlike a sort of a remedial claim by an unhappy shareholder who claims that his rights have been violated. It is not a petition by the dissenter complaining that something has gone wrong. It is a petition which the company itself has to bring simply in order to operate the express statutory regime for court assessment of the fair value. And it is a determination of the fair value of the shares of all dissenting members. The petition by the company shall be accompanied by a verified list containing names and addresses and so on. So you just manage to scoop up all the members, and that is important because the process for assessing fair value is a collective process for all dissenters who have not agreed a figure.
Is it implicit that that a dissenter who has been paid under subsection 8 is no longer a dissenter?
Yes, I think that must be right, because once he has been paid, his shares are cancelled.
9 is only if that there is a failure to agree.
Yes, exactly.
I'm just looking at all.
Yes.
Yes,
If you've agreed under 8, and the last line of 8 is the company shall pay to the member the amount in money forthwith.
Yes.
And under subsection 15, shares acquired by the company pursuant to this section shall be cancelled, and if they are shares of a surviving company, they shall be available for reissue. So we apprehend that if some dissenters agree a price and others don't, those who don't proceed under subsection 9, those who have agreed can't then withdraw their agreement and take the benefit of any uplift in price under subsection 9. But that is one, I suspect, of the many points that don't have to be decided in this case. And it may be that with further thought, a different answer might be produced. But that would certainly be my immediate response.
And the contemplation under 7 is not, I think, that they cease to be members, but they become members with very specific rights.
But 7 is only triggered by the giving of the notice.
Yes, but I'm just thinking that you couldn't say that just because somebody, yes, but they are still members even after that date.
Yes.
Yes.
But under 8, if they've agreed a price and the company has paid forthwith, their shares are cancelled, at which point they aren't members.
Yeah.
So I think, I mean, if 8 works according to its tenor, then 9 chronologically can only operate after the agreeing dissenters, if I can call them that, have been paid out and stopped being members, I think. Subsection 11, at the hearing of a petition, the court shall determine the fair value of the shares of such dissenting members as it finds are involved, together with a fair rate of interest, if any, to be paid by the company upon the amount determined to be the fair value. The important features of that, again, are obviously that the statute tells the court what it must do. The court doesn't have any discretion to order a different remedy. It must determine the fair value, together with a fair rate of interest, if any, and then the company, again, the surviving or consolidated company, is the entity that has to make the payment. And then subsection 12, any member whose name appears on the list filed by the company under subsection 9b or 10, and who the court finds are involved, may participate fully in all proceedings. I think actually subsection 12 may be a more complete answer to my Lord Briggs's question, because those who can participate are only those who are identified in 9b or 10, not subsection. If you're in subsection 8, you've been taken out.
And under 11 is the fair value to be determined as at the date of the determination?
I don't know if that has been argued. I think it was common ground in this case that the fair value was determined as at the date of the shareholder approval.
Right.
And as a result, I don't think that point was argued, but I don't know if different views might be taken on that. But that's certainly the common ground in this case.
Can you just help me how 238 works? Because it contemplates the continued existence of the company.
Yes.
And yet, on the effective date, looking at section, which is the date when the plan of merger or consolidation is registered by the registrar, that leads to a process, doesn't it, where the company that is not surviving gets struck off?
Yes.
Whereas 238, I think, assumes that the payment's going to be by the about-to-die company.
Yes. Which for this purpose,
if you put the two together, it might appear already to have been struck off.
Yes. I'm not aware that that is an issue that has been debated yet. And I'm not sure I have a glib answer for you.
I wasn't asking for a glib one.
Or indeed any. Can we
Yes,
perhaps think about that and maybe come back?
I thought the payment was to be made by the surviving company,
Well,
not the dying company.
Well, that's what I'm wondering.
That might in fact be the answer, and I think that is what I said when I was paraphrasing subsection 11. But it does say by the company. I will just need to remind myself why we say that must mean the surviving or consolidated company.
It might matter to have a clear understanding
Yeah.
of which company is making the payment when considering questions of fairness.
I'm grateful.
I mean, in this particular case, it's Shanda that makes the payment, isn't it, Mr. Crowe?
Yes, it is.
Yes?
Subsection 15 we've already looked at briefly. Shares acquired by the company pursuant to this section shall be cancelled, and if they are shares of a surviving company, they shall be available for reissue. Subsection 16, the enforcement by a member of his entitlement under this section shall exclude the enforcement by the member of any right to which he might otherwise be entitled by virtue of his holding shares, except that this section shall not exclude the right of the member to institute proceedings to obtain relief on the ground that the merger or consolidation is void or unlawful. Those, I think, are the only statutory provisions that we need to take you through. What we submit, as you will have seen as I took you through it, that the three elements that are important for our purposes today are first that a dissenter has an absolute entitlement to receive payment. He does not need to prove any wrongdoing. Secondly, the court has no discretion as to the order it makes. It can and must do only one thing. And the third point is that the language with which we are concerned is the expression fair value. That is what must be assessed, and that is what we are concerned with today. So far as the correct approach to interpretation is concerned, you don't need any introduction from me. Obviously, the words must be interpreted in context according to the purpose they were intended to achieve.
Can I just ask, does subsection 16 imply that if a member brings proceedings to obtain the fair value of his shares, he can't bring proceedings complaining of oppressive conduct?
Sorry, if he brings proceedings under 238 to assess fair value, he can't...
well, there's another section later on in this Act, or is it section 280, I think, under which you can bring a complaint of oppressive conduct and seek relief, rather like 459 of the 1985 Act.
My Lord, there isn't an exact equivalent to what is section 994 in England under the Cayman legislation. What there is a provision allowing the court to make a number of orders if a member brings a winding up petition.
Yes.
And one of the reliefs that could be granted instead of winding up is an order for a buyout of shares. That, it would appear, in our submission, would be excluded, because that would not be a petition saying that the merger is void or unlawful. Or at least it wouldn't necessarily be. I suppose it is, I'm just thinking on my feet, it is hypothetically possible that a just and equitable winding up petition would be brought on the ground that the merger is void or unlawful. But of itself, if the complaint was simply unfairness, well, the answer would be no, because unfairness doesn't mean that void or unlawful. So the exercise with which you are concerned is interpreting the words fair value in this context, we would simply start by observing that the bare words themselves might be contrasted with other language, which we will see in other legislation, which refer to deemed sales between willing buyers and willing sellers. We see nothing of that sort in section 238. We simply see the bare expression fair value.
There was a reference to purchasing shares in 8, wasn't there, Mr. Crowe?
Yes, in the sense that a payment is made.
Very well.
Yes.
But surely the fact that the company has to make an offer under this process suggests that that offer will be something other than the price negotiated under the scheme itself, which would be the market value anyway.
Exactly. That, your Ladyship's already on my third point.
Sorry.
My first point, it's simply on a pure question of language. We are talking fair value, not market price, not willing seller, willing buyer. We're talking fair value. So the very least one can say is that the language does not mandate the imposition of a minority discount, nor is it particularly suggestive of a minority discount which reflects a market view of the marketability of the asset. Taking that point a little further, as we saw from the brief extract I took you to in my Lady Justice Arden's judgment, the concept of a minority discount is a concept which reflects the marketability of a shareholding. In other words, it is a concept that is concerned with the value, the sale value of the holding.
On the open market.
On the open market. And if one thinks about a sale, what that connotes in our submission is a transaction in which an asset, the shares, is being transferred by a seller to a purchaser and is being acquired by the purchaser, a new shareholder, to hold as his asset. And in that context, the value of the share is the value to the purchaser of the asset he's acquiring, and hence the price he is willing to pay to the seller. But as we have seen, the operation of Section 238 simply does not involve a sale of the dissenter's shares in any relevant or meaningful sense, because the shares, as we have seen, are paid for by the company, not by a new shareholder. And the consequence of the operation of the statutory mechanism under Section 238(15) is not that the shares are then held by a new shareholder as the purchaser. They are cancelled. So in two respects, in two significant respects, the transaction is simply not a sale in any meaningful use of that word. It is a mechanism for taking out a dissenting member, but it is not a sale because the asset doesn't pass to a purchaser. And that, in our submission, is highly relevant when one is addressing the question of what is the fair value to be applied in the context of that kind of transaction. Specifically, we obviously say that it makes a nonsense of the legislative concept to apply a minority discount, bearing in mind the fact that the minority discount reflects the marketability of a minority shareholding, and that is not the context in which this exercise falls to be performed.
Can I just test that? I mean, there are, in the parallel, I agree, not quite the same, 994 English jurisdiction. It's common, I think, if a buyout is conceived by the court to be the solution, for the buyout not always to be by the majority, but by the company itself, leading to a reduction in the share capital and a cancellation of the shares. That doesn't of itself, does it, on English authority, mean that you wouldn't apply some form of discount if the shares that are being bought by the company and cancelled are a minority, and it's a case in which it's appropriate, would otherwise be appropriate to apply one.
Well, Lord, I was going to come to 994 separately in due course,
Yes.
but the short answer to your question is that the significant difference, and in a sense it slightly bleeds into the next point I was going to make, the significant difference is that under 994, the court is simply fashioning an expedient remedy to deal with a situation which is overtly a sale of a discrete packet of shares. That's by definition, a petitioner under 994 is coming to the court saying, I don't like what has happened to this company, I would like to part with this packet of shares. So there, specifically, it is dealing with a sale, a transfer of the assets that that particular individual has. Now, it may happen that because the majority shareholders personally don't have enough money, and maybe the company does, as a matter of expediency, the court decides to implement that purchase by requiring the company to make the purchase. But that is simply a mechanism the court happens to adopt under 994. As to the identity of the payor, it doesn't alter the nature of the transaction. Under 994, by definition, an individual is coming to the court asking for a discrete packet to be disposed of, whereas the next point, and this is the other element of the difference between 238 and unfair prejudice, what is the context in which the fair value is being assessed under 238 is a merger or consolidation under Part 16 of the Companies Law. All mergers and consolidations, however they're structured, all mergers and consolidations involve the vesting of all the assets and undertaking of all the constituent companies in a surviving company or a consolidated company. They necessarily involve a dealing with the entirety of the constituent company's assets undertaking and hence of its value. The surviving or consolidated company necessarily ends up with 100% of their value of the company in which the descendant holds shares as a continuing going concern. And because it is necessarily the entity which ends up with that benefit that is going to be the economic source of the payment, in our submission, it is obvious that the statutory intention under Section 238 was that the fair value was intended to reflect a proportionate share of the benefit that has gone into the continuing or consolidated company. Malone and Friends' case spends quite a lot of effort arguing that a shareholder does not, as a matter of law, own or have a proprietary interest in the underlying assets which the company owns. And that is entirely true as a matter of law. An economist might have a different view, because who owns other than the shareholders in one sense? But as a matter of law, we entirely accept that the company owns its own underlying assets, shareholders own shares. But that doesn't really answer the point, because our argument for saying no discount is not based on some legal theory that shareholders own or have a proprietary interest in the underlying assets of the company. Our argument is simply based on the statutory context in which these words fair value are used. The fact that what is happening in any merger or consolidation is a dealing with disposal of the entirety of the assets, benefit, undertaking, goodwill, value of a company, and that in that context, given that the court is required to assess the fair value rather than the market value, the presumption must be that no discount should apply. And just going back to those few words in the Strahan judgment, you will recall that Lady Justice Arden referred to the full value of a company, i.e. the non-discounted value, or the market value, i.e. with a discount. And in our submission, the full value or the fair value of a company are the same concepts. So our submission is not based, as I say, I wish to make that quite clear, our submission is not based on any heresy that shareholders own the assets owned by the company. They plainly don't as a matter of law. But as a matter of economics and as a matter of fairness in the context of 238, our submission is that they should have their proportionate slice of the cake whose size we already know.
Is it right to speak of a minority discount as purely and simply something which arises from the attitude of the market? For example, compared with the fact that a minority has less ability to decide or direct on where the company is going than either a 2/3, 75% or 90% majority.
Yes. That is why a purchaser would be less interested in buying certainly. A minority.
Yes.
Yeah. It is a reflection of how limited an attraction as a marketable asset the minority shareholding is. Yes. I mean, some people talk about control rather than value, but the limited control in a company which is exercised by a minority is reflected in the minority discount because a purchaser is less interested. This does slightly, I don't want to get ahead of myself because I want to keep everything in order, but it does factor into another point I'm just about to come to, but just to keep things in sequence, the next point I just wanted to get across is that the valuation under 238 is significantly different from an arm's length sale, because by definition an arm's length sale is a voluntary transaction entered into between a willing purchaser and a willing seller, whereas under section 238 the transaction operates under statutory compulsion, irrespective of the wishes either of the parties or of the court. Now, as we've seen, what the legislation gives the dissenter no option. He can't say, well, I'd like to keep my shares, and unless a price can be agreed under 2388, the mechanism has to be one in which whether the company wants to buy and whether the dissenter wants to sell or not, both are required to submit to the statutory regime, and the court has no option to fashion a different remedy. So it is a transaction under compulsion in that sense, and for that reason, again, entirely different from a sale. That leads into the next point, which is the fact that the outcome is mandated by statute is also important for a different reason in this context, because a share obviously is a property right. Absent a statutory regime under 238, a shareholder could not be expropriated against his will. So if section 238 had not been enacted, and if a majority wanted to merge with another company, and if in order to do that they had to buy out the awkward squad, the minority shareholder could expect, in fact, to negotiate an uplift on their sale value of their shares, either to reflect the fact that they were surrendering a power of veto, or to reflect the special value their holding would have to the person acquiring 100% control. So, again, the fact that that is what would happen in a market sale is another difference between a sale and the regime under section 238. 238 effectively imposes a statutory requirement that the dissenter surrenders his power of veto. And so, again, why should, in that context, the court then also impose a minority discount? That then also feeds into another important point, which is that in our submission, the statutory regime expressly contemplates a single fair value for all dissenters' shares. If you recall the wording in 238 subsection 9, the company shall file a petition with the court for a determination of the fair value of the shares of all dissenting members.
But hold on, the shares may be of different, they may have different rights. So
well,
if they do have different rights, then the court will have to determine a number of different values.
If there are different economic interests in the company, that is entirely possible. There might be a situation in which you have to value the cake, and then if you've got preferential dividend rights and non-preferential dividend rights, you might have to apportion the overall value of the company between the different classes of shares, but then, again, a dissenter within that class would have a proportionate right to his interest in that class of shares. But as it happens, again, that isn't an issue that has to be decided now, because it was common ground between the valuers in this case that the two classes of shares should be treated equally in this case. So that isn't an issue for you. But what is relevant is this, that it is the fact that different sizes of minority interest might attract different levels of discount. The discount that you would apply in a market to selling a 2% shareholding compared with selling a 49% shareholding would quite likely be different. As, for example, again pointed out in one of the authorities we've cited, the value of a 2% shareholding in a market transaction might vary depending on the identity of a purchaser. If a purchaser has just below 75% already, buying an extra 2% gets him over 75% and will therefore be much more valuable to him than a purchaser who only owns 4, 5 or 10%. So both the size of a minority holding and, for that matter, the identity of a purchaser will be relevant in a market situation to assessing the size of a discount. But what is clear in 238 is that a single fair value is required to be fixed by the court for all shares. And that, in our submission, very strongly suggests that no minority discount can be applied. Because if you were to apply a minority discount, you would be quite possibly having to come up with different fair values for different packets of dissenter shares. And that is simply not consistent with the legislative regime. That point we make simply by reference to the statutory context because of 2389 talking about the fair value of the shares of all dissenting members, and the fact, as we pointed out, that the dissenting regime is a collective process. But in a sense, the point is a bigger one because the law in our submission, particularly when approaching questions of statutory interpretation, should certainly prefer an interpretation which achieves certainty and clarity and reduces the risk of disputation and litigation, rather than an interpretation which maximizes the risk of disputation and litigation. Any valuation exercise is complicated enough for any court. If you were to uphold the Court of Appeal's decision in this case and agree that minority discounts can be applied, you would be adding to the menu of issues that will fall to be disputed in future 238 cases, because there will then be squabbles over the appropriate amount of a discount, bearing in mind the size of any minority holding held by dissenting shareholders. So for the interests of clarity and certainty, a bright line principle that no minority discount is appropriate in this context would be appropriate. A brief word about law from other jurisdictions. Delaware and Canada, you will have seen referred to. We've got a lot of case law, but I want to deal with it relatively lightly for two reasons. One is time, but the other is because the relevance of this foreign case law is more to be derived from the fact that it is there, or certainly that it was there at the time that the Cayman legislation was introduced, than anything else. If I could just explain, it is common ground that when Section 238 was introduced into the Cayman Islands in 2009, comparable legislative regimes had existed in other jurisdictions, particularly in Delaware and Canada, for many, many years. And it's equally common ground that it was well established in the case law of both jurisdictions that the concept of fair value in this context required a pro rata valuation and no minority discount. Now, as I say, we mention this point not because you are in any way bound by the views of Delaware courts or Canadian courts, but the fact that that was the established case law in jurisdictions which already had a comparable regime using the expression fair value is important context for you to answer this question, which is, in 2009, when the Cayman legislator chose to introduce this regime and to use the expression fair value, which had been used in Delaware and Canada, and which had been interpreted to mean no discount, did the Cayman Islands legislator, by using those same words, intend the Cayman courts to produce a different result? And in our submission, the answer is plainly no. So one could spend a day holding up to a strong light the logic of the Delaware analysis of the Delaware legislation, and indeed the antecedents in other states. But that's not really a valuable exercise, because the point that matters is that it was common ground that the legislation in those other jurisdictions had been interpreted clearly as not requiring a discount. A decision was taken by the legislature in Cayman to use the same expression, fair value. So the inference we invite you to draw is that that choice was taken because the legislator here, for these purposes here, in the Cayman Islands, it intended to produce the same result. And without going through the case law in any detail, the fact that that was professional understanding as well is most clear from an article which is in the Authorities Bundle 8, tab 84.
I beg your pardon, the bundle?
Authorities 8, tab 84, or electronic page 4238. It's only a few pages long, but I'm certainly not going to read much of it. I just wanted to draw to your attention on page 4240, right-hand column, under the heading, So What is Fair Value and How is it Determined? It starts out in the first paragraph by saying that the courts hadn't, at the time this article was written, had to grapple with that. But then the second paragraph says, the absence of local jurisprudence is not, however, greatly concerning. Both the meaning of fair value and the approach to be taken in determining what it is are trite under Delaware and Canadian law. And given that their regimes heavily influence the drafters of Part 16, the Cayman Court should find the decisions in those jurisdictions highly persuasive. In the author's view, having regard to the principles established in Delaware and Canada, the Cayman Court should have little hesitation in accepting the following propositions if or when called upon to determine fair value. And then a number of propositions are set out, and just for brevity, over the page, 1.2 near the top of the left-hand column, it is neither appropriate nor permissible to apply a minority discount when making the determination. 1.2, top left-hand column. So that was clearly a received view in the professions, and in our submission it provides an important piece of the context against which the legislation needs to be interpreted. For what it's worth, we have, as I say, a considerable amount of the Delaware case law in the authorities bundle. The one point I would just wish to head off is this. My learned friend says that the Delaware interpretation is based on judicial policy, not on statutory interpretation. Our submission in answer to that is, first of all, it is wrong. If one looks at the fons et origo of this whole approach in Delaware are two cases. One is called Chicago and Munns. I'm not going to get them up because I don't have time, but Chicago and Munns, which is in Authorities Bundle 3, tab 36, page 2722. Chicago and Munns is one of the first Delaware cases that had to grapple with this question, and it looked at the legislation that had been passed in other states, in particular New Jersey. And New Jersey had expressly used language in its legislation which indicated that a market value was the appropriate approach, and Delaware deliberately chose not to follow that model. And for that reason, the Delaware court took the view that fair value was not intended to reflect just market value. And the other case is Cavalier Oil and Harnett, which is Authorities Bundle 3, tab 32, page 2622. And that followed on from Chicago and Munns, and it says in terms on the right-hand page, page 2622, that the argument in favour of applying minority discount is, in my view, unsound because its premise runs counter to the statutory policy underlying the legislation. It refers in terms to the statutory policy. It doesn't say this is some sort of abstract judicial invention. Those two are the founding cases for the Delaware approach. So in our submission, he's not right to say that the approach in Delaware is some judge-made invention entirely independent of the legislation. It is judicial interpretation of the legislation. But the second point in answer to Melania Friend's argument is that, as I say, in the most important sense, it doesn't really matter, because what matters for your purposes is not to conduct a critique of the quality of Delaware case law, but to recognise that when the Cayman Islands chose to adopt this legislation, they were doing so against a context that was Delaware law, and that Delaware law, that the Delaware legislation had been interpreted in the way that I've indicated. And the final point in relation to this is that the position is equally clear in relation to the Canadian case law. There's no Canadian case law that says this is judicial invention, not statutory interpretation. If you want it, there's a very useful, perhaps overlong article on the position in Canada in volume 8 of the Authorities. Again, I'm not going to take you to it now in the interests of time, but it's volume 8 of the Authorities at tab 82, and it starts at page 4164. There's a very short passage on page 4179, which makes clear that it's well established that there should be no minority discount in determining fair value.
Crowe, the words fair value conjure up in some minds a relative concept of fairness between persons. Do you accept that that is a concept imported by its use here? And if so, who are the persons as between whom the value should be fair? I can obviously see that the dissenters are on one side, but bearing in mind that the buyer can be the constituent, brackets, dying, close brackets, company, new co or the consolidated company, I wondered who might be regarded as those on the other side.
In our submission, the best and simplest answer to that question is to say that the fairness must be dictated by the circumstances of Section 238, which embrace all the considerations I've identified, namely that it is not a sale in any natural sense. It is not a transaction between parties who can be assumed to be willing on both sides, and it's not a transaction which involves a transfer for value of an asset which is then held by the recipient. So the fair value concept reflects its statutory content.
Sorry.
No.
So, for example, you could take into account that the purchasers group, including its associates, had procured the passing of the special resolutions.
In our submission, the approach, the best and clearest approach is simply to adopt what we apprehend from the Delaware and the Canadian case law, which is simply as a matter of principle, a minority discount is not an appropriate thing under Section 238.
And you say that should be the bright line rule, no minority discount, but that's not the only provision. You can add in for other things, but the only matter you argue for now is simply no minority discount.
Indeed.
Ever.
Yes.
But you could have additions to take account of other things, such as if assets had been expropriated before the date of the valuation, misappropriated.
I think there is, in fact, quite a lot of Delaware case law on a separate point, which we fortunately don't have to grapple with, which is essentially, if I can just put it in one nutshell, if there is also an allegation of misconduct that might, for example, found a 994 petition in England, that is not what the Section 238 regime in Cayman is designed to deal with. 238 values what you've got, not what you should have, but for some misconduct. So there's quite a lot of case law in Delaware, and the result of that is that in Delaware it is not uncommon to have effectively a misconduct claim running separately, running in parallel with what they call an appraisal claim. Because the view taken there is that an appraisal is to value what you do have. A misconduct claim, whether it's breach of fiduciary duty, derivative action, unfair prejudice, minority shareholders petition, or whatever process, is there to achieve a remedy for a wrong. Appraisal is not a remedy for a wrong. It is a valuation of what you do have and what you're having to surrender.
Well, I'm just going to ask about that. But in this legislation, we know that once the notice of dissent is given, then under 238 subsection 7, the member ceases to have any of the rights of a member, except the right to be paid fair value.
Yeah.
And we saw earlier that under 16, specifically, he's prevented from enforcing any right to which he might otherwise be entitled.
Yeah. Well, as I say, it's not really my purpose to argue whether the language of 238.16 is or isn't wide enough to permit a just and equitable winding up on the grounds of wrongful conduct. All we would say is that, bearing in mind that the regime under 238 strips you of all but the most sort of nuclear options of challenging the validity of a merger or consolidation, that in our submission is a powerful argument for not imposing a minority discount, because otherwise the dissenter is at the mercy of what some of the cases have called, as you will have seen, abuse. That's precisely the rationale underlying some of the Delaware case law, is that there is a risk that a controlling interest in one of the constituent companies can get the 2/3 majority at a significantly below full value, to borrow Lady Justice Argan's expression, push through a merger and consolidation, and it is not unknown for this take-private mechanism to be used in a way that advantages incumbent management or an incumbent majority shareholder to take private an entity which is undervalued on the market, push out a minority, and then either sell on to an independent third party or refloat at a very enhanced figure. And it is against that kind of abuse that the true value, the fair value of the dissenters' shares must be assessed, because otherwise there is an inherent risk that the rather modest majority that is allowed to push these things through will be using the regime to its own advantage.
While you're on abuses, why do you have to exclude the possibility of an addition for the misconduct claim? Your only answer is, well, Delaware does because it has the separate misconduct claim proceeding. So why does Cayman necessarily buy into that part of Delaware law?
It doesn't necessarily, and I would not wish to give an unequivocal answer to that. It would there would have to be at least two debates about that. One is whether just within the process of 238, one could complain of misconduct and deliberate abuse. The other question is whether 238 subsection 16 is actually broad enough to allow a separate claim for a just and equitable winding up, which might then lead to a fair purchase by that route. I'm short of time and long on items I haven't yet covered. Can I just move through what is left as economically as I can? I've addressed you essentially by reference to the words and the context in which they're used, part of the context being pre-existing case law from other jurisdiction. All of that was, in our submission, properly taken into account in the first case in Cayman that had to grapple with this question, the decision in Integra. That is in Authorities, I don't ask you to go to it, but just for your note, it's in Authorities Volume 2 at tab 28. And although, in fact, it was common ground, it's page 2489 in the electronic bundle, it was, in fact, common ground in that case that no discount could be applied. And that may well, again, also tell you something about the integrity of the argument in favour of a discount, that the company in that case didn't even consider it worth pursuing. But in any event, the decision did conduct a careful review of the principles underlying 238, how it was viewed professionally and how it was viewed in other jurisdictions, and came up with the answer that we submit is the right one, which is also the approach that was taken by the judge at first instance in our case. It's the Court of Appeal in our case which has departed from that, and in our submission they had no good reason to do so, and the reason they departed from the case law that had previously been decided in Cayman is that they were, with respect, distracted by the ingenious arguments on behalf of my learned friend, which he will be perpetuating in front of you today. Interestingly, he is now putting front and centre the decision in Short and the Treasury Commissioners, which you will see him having dealt with in his written case at some length. It was a decision that was cited in this case at first instance. It received, I think, a line and a half of dismissal in the judgment at first instance, paragraph 93F. So far as we can tell, it wasn't cited in the Court of Appeal at all. It's certainly not mentioned in the Court of Appeal judgment. And it is, in the circumstances, surprising that my learned friend regards this as his life raft at this level. We will obviously hear what he has to say in a few moments, but could I just put four thoughts in your minds preemptively in relation to Short? The first is that when you read in particular, well, actually, I don't mean in particular, both the Court of Appeal and the House of Lords decisions, It is expressly and repeatedly stated to be a decision on the construction of the regulations in question. It is not an expression of any general principles of law at all. The second point is that the wording of the regulations in question expressly referred to a presumed sale between a willing buyer and a willing seller. That is self-evidently different from ours. The third is that it was not only legislation that used that language, it was legislation whose architecture, so to speak, produced that result, because it was a purchase of shares, properly so called, not a mechanism for cancelling shares and taking a shareholder out of the equation. And the fourth point is that the House of Lords said in terms that it derived no assistance at all from considering other wartime expropriation legislation. It was a wartime expropriation case itself, but the House of Lords didn't even derive any assistance from other wartime expropriation legislation because they were differently worded. And in the circumstances in our submission, it is ambitious of Shanda now to say that a case which has those features should be read across to Section 238, which has contextually and linguistically absolutely nothing in common with it. The other categories of case that were cited in the Court of Appeal and which, in our submission, wrongly distracted the court there, if I can just deal with them relatively briefly. The first was a number of cases dealing with the squeeze-out provision in a takeover, and you will recall that we looked at that briefly in Section 88 of the Cayman Islands. The Court of Appeal in this case, in paragraph 35A of its judgment, looked at some English squeeze-out cases, and it drew from those English squeeze-out cases an understanding that a minority discount was appropriate. The responses we have to that, very briefly, are first, and most importantly perhaps, self-evidently, the English squeeze-out legislation, which was being considered in the case law the Court of Appeal took into account, simply doesn't use the expression that you are construing. It just doesn't use fair value. Secondly, Cayman has an exact replica of the English squeeze-out provisions, but in a completely different part of the companies law, as we saw. Section 238 on mergers and consolidations is in Part 16. Section 88 is in a much earlier part. I'm not just making a structural point. The point is that if the Cayman legislator had intended the court in relation to mergers and consolidations to adopt the same approach as in a squeeze-out, it would have applied Section 88 to the dissenter regime. But it didn't. It set up an entirely independent regime for valuing dissenters' shares under Section 238. It did not apply Section 88. And that is significant because, as we saw when we looked briefly at Section 88, the architecture of that provision is totally different from Section 238. It's different in terms, first, of the majority that's required. It is different in the sense of the nature of the proceedings that may then follow, because as you will recall, under Section 88, if somebody doesn't like a price that is offered, it's the dissenter that has to make an application to the court, whereas under 238 it must be the company. Under Section 88, the court has a discretion what to do. It can order otherwise, but it doesn't have to. But most importantly, and this is what really comes out from the English case law, is that the whole philosophy, so to speak, of Section 88 is that if 90% of the members of a company have taken a view as to what is an acceptable price, the court under Section 88, when it is deciding on the dissenter's application whether to order otherwise, is starting from a presumption that the 90% know what's in their financial interests.
Well, assuming they're not also on the buyer side.
Well, that's yet another point, which is that if they are all on the buyer's side, then the court doesn't even start with the presumption that the bugle press, your lordship's already on that point.
But isn't that going to be a fundamental feature in the court's appreciation under a Section 38 application by a disgruntled minority about what is the fair value of the dissenting minority's shares?
My Lord, in our submission, it is simpler, preferable on principle to adopt an approach which does not seek to scrutinise, so to speak, the balance of power at shareholder level, because the court is simply assessing fair value in which the valuers can agree what the size of the cake is. If a dissenter holds shares in an undertaking, the entirety of which is being transferred, a principled approach is to give him a proportionate share of that entirety. That doesn't depend on proving any abuse or wrongdoing, because none of that is a precondition under Section 238. I hope you won't mind. I'm going to bite something off my reply, if I may, and keep going till about 1:15. Otherwise, I won't get through the material. The starting point under Section 88, the squeeze-out provision, is that the transferee company is entitled to buy at the takeover price unless the court is persuaded to order otherwise. So there is first of all, there's a starting presumption that the court is going to enforce the takeover price. The onus is therefore on the dissenter to prove that the takeover price is unfair and therefore should not be followed. The question for the court is not, would I, the court, come up with this particular number, but has the dissenter proved that that number is unfair? Now, it is stating the obvious to say that different people can come up with different fair values. But the really important architectural difference between Section 88 and Section 238 is that Section 88 has built into it a presumption that the takeover price is the right price which the court is going to enforce, unless the court can be persuaded to do something else, which throws an onus on the dissenter, and the onus is to prove that the takeover price is unfair. Now, neither of those features are present in Section 238. 238 isn't even a claim by a dissenter at all. It's a petition by the company. And the court starts the valuation process with a completely blank sheet of paper. It doesn't start assuming that the merger price is the right price. 238 does not have in it what Section 88 has, which is a requirement that the court shall order the shares to be bought on the terms of the merger, unless it thinks fit to order otherwise. The court starts with a completely blank sheet of paper. Now, my learned friend has said many times in his case, well, you should not start a valuation assuming something has gone wrong. You should not start the valuation process assuming there has been some sort of abuse or misconduct by a majority. Now, in one sense, that is quite true, but it is equally true and very important to say that you do not start, the court does not start the valuation exercise under 238 assuming that the merger price is the right one. Because if the starting presumption was meant to be the merger price is the right one, you would have had language like Section 88 saying that the court orders if the merger price had been the right one, you would have started with the court ordering the dissenters to sell at the merger price unless it thinks fit otherwise, thinks fit to order otherwise. And that's exactly not what Section 238 does. So built into 238 in our submission is, if not an assumption that the merger price is wrong, at least an extremely open mind that it may well not be right, because the merger price is not stipulated as the starting point, and there is no onus on the shareholder, the dissenting shareholder, to demonstrate any unfairness or to, in the merger price. So, for those reasons, we submit that the squeeze-out cases that the Court of Appeal looked at in paragraph 35A of its judgment are not relevant to the interpretation of 238, and indeed the difference between the squeeze-out regime under Section 88 and the merger consolidation regime under 238 point strongly in favour of the correctness of our submission. As it happens, final point on squeeze-out, as it happens, we also submit that the Court of Appeal in this case, in any event, drew the wrong lesson from the English case law that they looked at. The Court of Appeal seemed to think that the English case law on squeeze-out actually supported the imposition of a minority discount on the dissenting shareholders. It doesn't, because the issue in the squeeze-out cases, as I say, is can the minority dissenter prove that the takeover price is unfair? So what the minority shareholder is actually seeking is an uplift on what all the other shareholders have found to be a fair and proper price. A minority discount is a description of a process under which you've worked out how big the cake is, you know what the percentage shareholding of the minority is, but you don't give them that proportion of the cake, you give them something smaller. You value the company, and then you discount the proportionate share of the dissenter. That's just not the issue in the squeeze-out cases, because the squeeze-out cases were all cases in which the minority was saying, well, actually, the size of the cake has been valued wrongly. I need an uplift to reflect a fair value for my shares. So in our submission, the cases that the Court of Appeal relied on simply don't support the idea that having valued what the company is worth, you then apply a discount to the value of the shares of some of the shareholders. That just wasn't what the cases are about. And the final point in relation to this, as we've pointed out in our written case, but just to make the point orally, the final point is that the Court of Appeal in our submission overlooked the principle, general principle 1 in the City Code on takeovers, which is that all shareholders in the same class must be afforded equivalent treatment. And self-evidently, a minority discount involves a discriminatory treatment of shareholders in the same class. The second distraction for the Court of Appeal was a line of authority on English schemes of arrangement, and that's paragraph 35B of the Court of Appeal judgment. So far as that is concerned, again, we make some very similar points. The first is that the English legislation that those cases were dealing with, English schemes of arrangement cases, simply don't use the words that you're construing, fair value, so they are of no assistance to the exercise of construction with which you are engaged. Second point, exactly again as with squeeze out, the second point is that Cayman legislation itself contains a scheme of arrangement provision in section 86, which is entirely separate from and different from the section 238 regime. So if the Cayman legislator had intended the court in a merger or consolidation to produce exactly the same results as were produced in relation to schemes of arrangement, there would have been no point in introducing a completely separate statutory regime using different language to deal with mergers and consolidations. So the separate existence of Section 86, which again we looked at the very beginning, strongly argues against producing in mergers and consolidations the outcome that may be produced in schemes of arrangement. And the third point, again, similarly to the submission on squeeze-out in takeovers, the third point is that in relation to schemes and arrangement, one is looking at a regime in which there is a different statutory majority required, 75% for a scheme of arrangement, a different procedural protection, so to speak, because in schemes of arrangement, even with the statutory majority having been established, the court must give its sanction. Obviously in 238, no court sanction is required. Under Section 86, separate class meetings will be required of different classes of shareholders, and that doesn't just mean the formal separation of shares into different classes with different class rights. It can also embrace, as one of the cases we've included shows, Hellenic and General Trust. It can also mean that the court will require separate meetings to be held of interested and disinterested shareholders, in the sense that if there is a body of shareholders in one of the constituent companies that is going to be ending up essentially as part of the surviving entity, they are going to be in a different position. They have different interests because they are going to be both purchaser and seller. Whereas if the dissenter is not being offered shares, as in this case, the dissenter is being offered cash, not shares in the surviving entity, he's clearly going to be he is nothing but a person parting with shares. He's not both seller and buyer. So for that reason, the protection that operates under Section 86 is more rigorous than the protection under Section 238. But again, finally, we submit that the Court of Appeal in our case simply drew the wrong lesson from the English case law because it seemed to believe that the English case law on schemes of arrangement approved the idea of a minority discount, and the English case law simply doesn't. The question of valuing the company and then discounting the price that some shareholders get compared with other shareholders simply didn't arise. The third distraction that the Court of Appeal was offered and succumbed to in this case was English case law on Section 994, that is, unfair prejudice petitions. So far as that is concerned, the headline points that we would make are, first, that the function and, again, the statutory architecture of Section 994 is entirely different from Section 238. So the court should never have been drawing the inferences it did from the Section 994 case law. Section 994 is a remedy available at the request of a usually minority shareholder where there has been unfair prejudice in the management of a company. There is therefore an onus on the shareholder to prove unfairness and a discretion in the court as to what to do. But again, as I said in answer to my Lord Briggs's question, by definition what is happening in a 994 case, the court is exercising that discretion. If it does so by ordering a buyout, it is by definition valuing the shares in the context of a discrete transfer of that packet of shares to a transferee, and not, therefore, necessarily in the context of a merger or consolidation which involves a disposal of the entirety of the assets and the undertaking of the company. And that is the single most significant difference. So it is entirely understandable that under 994, what is being looked at is a sale of the shares in which minority discount being a reflection of limited marketability has a role to play. But the second point we would also make, and I will tread relatively carefully here, but the second point we would also make is that the case law on Section 994 does not speak with one voice by any means. The Court of Appeal assumed that there was a bright line rule that you don't, that you do apply a minority discount in a buyout under Section 994 unless the company is a quasi-partnership. As we have pointed out in our written case, although there are some decisions, and the one we looked at the very beginning, Strahan, the remarks of Lady Justice Arden suggest that it is highly unlikely that a non-quasi-partnership company would be valued without a discount. But the fact is that there are a number of cases which we've included in the authorities bundle. We've got Blue Index, Adbins, Sunrise Radio, and Estera. And there is also a considerable amount of expert commentary from David Chivers QC and Robin Hollington QC, each of whom have produced textbooks on the subject, which indicate that certainly the drift of decisions at the moment is in favour of a general rule in 994 cases to order a buyout at a full value, not at a discounted minority value, irrespective of whether the company is a quasi-partnership. And that is certainly the approach that's been taken in Scotland. We have included the decision in Robertson, Authorities Bundle 8, tab 79, page 4112, and the relevant passage is at page 4131. Decision of Robertson, the opinion of Lord Glennie, where he said in terms, in a case where the court is persuaded that it's appropriate to make an order that one party purchase the shareholding of the other, the price fixed by the court will normally be a fair value without any discount being applied for the fact that the shareholder being purchased may be a minority shareholding. This is because the party selling is not a willing seller, putting the shares on the market and accepting the reduction in price usually associated with the minority holding, but is being forced to sell to remove an impasse which is not, or at least wholly, of his own making. The normal approach will be to value the company and attribute pro rata valuation to the shares in it. In our submission, the logic of those observations applies well in the context of Section 238. So far as the last two categories of distraction in the court below were some Bermuda and BVI case law and legislation. So far as that's concerned, I don't have anything, I think, really to add to our written case. Our arguments on that, I think, are perfectly clear and speak for themselves. That's paragraphs 34 to 36 of our written case. And finally, the fifth element of distraction in the court below was the observations of Lord Millett in CVC and Opportunity, which again, we don't have really anything to add to what we said in paragraph 38 of our written case. The CVC, as you may recall, was actually a decision on an application for an injunction to restrain the presentation of a winding up petition. It plainly wasn't a decision on 238 in any sense, and was decided long before 238 came along. It contains, again, some general observations about when, under Section 994, the court might or might not apply minority discount. But the relevant passages, as we point out, are obiter. And your lordships and my lady will not, in our submission, find any real assistance from that. The outcome in that case was, as it happens, not to apply a discount. But the real decision in the case was whether it was an abuse to present a winding up petition in the particular circumstances of that case. So it is very dangerous to try deriving any real assistance for your purposes from that decision. So those last few distractions I've taken very fast, but as I say, I don't think you will be assisted by me adding to what is said in our written case. Really, in conclusion, what we found striking about Shanda's case on the minority discount point is that it barely mentions the Court of Appeal judgment it is seeking to uphold. And in our submission, there is a good reason for that. The Court of Appeal judgment in this case went down wrong paths because it was distracted by a raft of case law on other provisions which simply don't have the same purpose, philosophy, or language as Section 238, and the right outcome in our submission are the two domestic Cayman decisions, Integra, and the first instance decision in this case, that a general approach should be taken of not applying discounts in 238 valuations. Unless there are any other points, which there may be. Yes, in answer to my Lord Briggs's question as to the identity of the payor company.
It seems to be there's an option for either of the three conceptually possible companies to make the offer.
Yeah.
Subsection 8, isn't it?
Yeah, exactly.
Because the constituent company must be the one that's facing death.
Yes. Or the surviving company, consolidated company can make an offer under 8. If that, so when you get on to 9, if it's that company, whichever that company is, right, and the dissenting member failed, I think, yes, I'm grateful.
But the fact that Shanda is still here rather suggests that the anticipated strike-off has been sort of almost indefinitely postponed.
We'll have to hear who my letter friend appears for. Yes. My Lord, I have nothing else in opening. I'm very grateful.
Mr. Bell, do you have anything to add? Mr. Jones.
My Lords, my lady, I'm going to be following the structure of the case, so that might be useful to have open. I've got limited time to get through it, so I will be summarising various parts of it. The starting point, just by way of introduction, is that the Delaware approach and the approach which the Maso parties urge this committee to adopt is to value the company's undertaking as a going concern and then to determine the fair value of the shares as being equal to a pro rata interest in the company's undertaking. We say that a share is not a proportionate interest in the company's undertaking, but is a share in the company's share capital. And where the legislation directs the court to value shares, what must be valued are the shares. That is, the bundle of rights that the shareholder possesses by virtue of the ownership of the shares. And we can start by taking up the case at page 3, the electronic record 2057. At paragraphs 18 and 19, we've set out the statements by the judges in Short and Treasury Commissioners as to what a share is. It has no direct share in the assets of the company. It has such rights as the memorandum and articles give the shareholders. And Lord Justice Evershed, they're not in the eye of the law, part owners of the undertaking. 21, the thing that a holder of a share has is a share of the share capital. That clearly finds its way in the legislation. We've set those out at 22 to 24. And then at 25, we point out that from an accounting point of view, the capital of a company stays the same, regardless of whether the assets of the company go up or down. If there's only one class of share, and I'm on paragraph 26, if there's only one class of share, it's very easy to elide the value of the share as being a proportionate interest in the value of the company, but that breaks down when you have different classes of shares. In paragraph 27, we use the example of a share capital of $1,000, 1,000 shares at $1 each. You have 800 ordinary shares. You have 200 preference shares. The 200 preference shares have 20% of the share capital of the company, but that doesn't give them 20% of the value of that, 20% of the value of the company overall. Similarly, with the 800 shares, the ordinary shares, it's just not possible to say that shares have some form of proportionate interest in the value of a company.
That's because you're looking at nominal value. That's
Yes.
not the only way of valuing a share.
Oh, it's not the only way of valuing a share, but it's really, I'm taking issue with this whole idea that somehow, if you can actually say that a particular share has a proportionate interest in the value of the company. It just doesn't, it just has no logic to it.
Well, there is a logic when a majority shareholder sells. You would then ask what is the proportion of the company being sold.
Well, if all you've got is one class of shares, then it's very easy to just to do that. But the logic of it breaks down. But the majority may well have a control premium, which they have and which they can sell. And if what you do is to say with just one class of share, well, what you've got to do is to give each share as a fair value, a proportionate share of the value of the company. It's those who have a control premium.
Well, it's clear from the evaluation of the dissentient shares that any type of control premium which a minority shareholder has is left out of account and has to be shared with the other minority shareholders who are dissentients.
Yes, but it may be that there are different amounts of minority shares.
Indeed, but that has to be levelled out. Everyone gets a valuation of a single share.
Well, that's the argument of my opponent.
Indeed, but even on statutory construction, every dissentient will get the same amount.
No, I say that's not right.
Yep.
Might it be worthwhile, because of that question, going to section 238, which is in the Authorities Volume 1, divided, it starts at 2225 on the electronic record.
Can I ask Mr. Jones?
Yes.
But before we go to that, I'm slightly puzzled at the moment as to whether we're dealing with either a merger or a consolidation as defined.
Well, actually what we're dealing with in this case is a merger, but I don't think the principles differ.
And a merger is defined as the merging of two or more constituent companies and divesting of undertaking property and liabilities in one of such companies as the surviving company. And surviving company means the sole remaining constituent company into which one or more constituent companies are merged. As I understand it, both companies survived in this.
No.
The judgment says that Shanda became a wholly owned subsidiary of Capital Corp.
Yeah, it's confusion between, there's a Capital Corp and there's another company called Capital something. I don't have them at the top of at my fingertips.
Yeah.
But what happened was that the two companies, one of them is called Capital something.
Yes.
And that merged with Shanda and it disappeared.
Oh, I see. Right.
And Shanda becomes a wholly owned subsidiary of another company which has the word capital. I just can't remember the two of them, but that's how it works.
That's helpful, thank you.
So you had
Shanda is a surviving company.
Sorry?
So Shanda is a surviving company.
Shanda is a surviving company. I was just going to go to section 238. And if I can just quickly go through this to deal with the point that my Lady Arden made, it starts off under subsection 1, a member of a constituents company incorporated under this law shall be entitled to payment of the fair value of his shares. It's directed to his shares. Then subsection 3, an objection under subsection 2 shall include a statement that the member proposes to demand payment for his shares. Then we have 5, 6, and 7. A member who elects to dissent shall give the details of the shares, and the member shall do so in respect of all shares that he holds in the constituent company. And one has to go through this on the basis that there are different classes of shares, so that the dissenter may have preference shares, may have ordinary shares, may have other types of shares. And what he must do is to dissent in respect of all those shares. You cannot cherry pick. You've got to dissent in respect of all of them. Then in 8, an offer has to be made to each dissenting member to purchase his shares at a specified price that the company determines to be their fair value. So it's all geared to the shares held by the particular dissenting member. And then we come to section 9, and it's this section that my learned friend puts a huge amount of weight on. If the company and a dissenting member fail within the period specified in subsection 8 to agree on the price to be paid for the shares owned by the member within 20 days, and this is what they rely on, the company shall file a petition with the court for a determination of the fair value of the shares of all dissenting members. It's not saying that they've got to all have the same value. Indeed, on the basis that there are different classes of shares, there'll plainly be different values.
Well, clearly, different classes are one thing.
Yes.
But within a class, will an offer in the context of a merger or a consolidation not be made on the footing that a certain price per share is being offered?
This is the way that not so much in the oral submissions, but in the case, the way the other side put their case is that these are all dealing with the acquisition of a company and the extinguishment of all the shares for a price. One has to be very careful that there are many other situations where the merger provisions operate. So take a situation where you've got Company A wishes to take over Company B. So Company A is proposing that the two companies will merge and all the shareholders in Company B, their rights will be extinguished for the payment of a capital sum. However, the way the merger provisions work is that each shareholder in Company A also has a right to dissent. So It's whenever there is a merger or a consolidation, regardless of what the details are of that merger and consolidation, every shareholder and every constituent company has the right to dissent. So one mustn't look through this through blinkers and see it as a takeover and the potential abuse of a minority.
Well, in a situation such as the one we're dealing with, is it conceivable that that offers would be made for shares on the footing that the amount being offered would depend on a number of shares you held?
Oh, the standard takeover, you make an equal offer to
Yes,
all
of
shareholders. But that doesn't mean that that's equal to the proportionate value of those shares in the company. Because what happens is each of those will have a minority shareholder. Therefore, there'll be a discount to the, let's call it the proportionate value of the company. If what you're going to do is to make a takeover, then generally what you will do will be to make an offer which will be above what they're trading at, but less than the total value of the company. And that's the bargain that you have to strike. So yes, you will have an equality of offer, but that doesn't mean that what you're offering is a proportionate value of the value of the company. And I'll come on later, and it's that point that is the significant point of the squeeze-out and the scheme of arrangement cases, which is it is not per se unfair that a shareholder gets less than a proportionate value of the company.
But as you say, I mean, 238 is meant to address the situation where the amount being offered doesn't match the dissenting shareholder's view of the value of their shares. And what they're looking for is a higher offer per share than has actually been made.
Well, they may be, but the basis on which this is all going through is that the directors have acted properly, that the majority shareholders have acted properly. If what they've got is a complaint that they should have been offered a higher price, then they have to make the allegations that this hasn't been conducted properly. What we say is that goes down another route that isn't what we're considering with the appraisal process, because by definition, what each dissenting member wants is for the company to continue as it was before, without the merger or consolidation. That they're dissenting from the merger and the consolidation. The functions.
Well, they may just be dissenting about the price.
Well, they don't have a legitimate ground to complain about that unless they can say that there has been an abuse.
Well, they may just bona fide take a different view about value. I'm not sure that one has to just because there's a difference.
In the case where where they're going to be extinguished for cash, yes. But there are many other situations where they simply don't want the merger to go ahead. They're not being offered.
Well, the trigger to subsection 9 operating is the inability to agree a price under subsection 8.
Exactly, but the offer under subsection 8 has to be to each person. There's no requirement to give a same offer to each shareholder. If, even within one class, if one shareholder has a premium element, then that shareholder has more value than somebody that has a minority element.
Yes, but the effect of the valuation provision here is that you share out that premium among all people in the same class.
Well, that's the argument.
That's what it says, isn't it?
No, it doesn't.
Well,
What 9A is doing is simply providing the mechanism by which everything gets to court.
In one proceeding.
In one proceedings. That's all that 9A is doing.
Yes, but then you get to 11, at the hearing of the petition, the court shall determine the fair value of the shares of such dissenting members as it finds are involved.
But that's
it doesn't
not
say the fair values of the shares. It's looking for a single valuation.
Well, it must be fair values because there'll be different classes of shares.
Well, that's a separate issue, whether there are different classes, But you're saying within an individual class, you could have a shareholder who has a larger percentage of shares than another, and he could have negotiated a premium, possibly, by private treaty.
Yes.
But we're not in that situation where we're with the court making evaluation, and the statutory indication, I had thought, you're going to tell me otherwise, is single valuation for single class.
Well, my lord, my lady, I don't see that can be read like that at all, my lord. Because my lady, first of all, there will be separate valuations of separate classes, so one can't read that those provisions are somehow dealing with one single valuation. All it is dealing with is that you put them into one petition, because there are obviously going to be overlapping issues relating to the overall value of the company. So you put it into one petition at 9A, and then all Levin is dealing with is that the board then has to deal with the valuations of the shares of the centres. There's nothing in that that says it has to be some equality.
The consequence of this in the context of a private company, for example, might be that the fair value could be, on your approach, could be well below the value per share that had been made in the offer.
Yes.
Yeah. Because a minority shareholding in a private company might not be worth very much at all.
And absolutely, and many of the cases that are going through Cayman now, they're arguing that the fair value is less than the merger value. And we say there's nothing in the statute that dictates that that can't be the correct solution.
Yes.
We then come to short and treasury commissioners, which is on page 8 of the case, page 2062. And the significance, we say, of this case is that it just points out inherent problems with adopting the Delaware approach. Yes, the regulations are differently worded. But the important point is that the judges considered it on a fundamental basis. So if one goes to paragraph 42 at 2064, the issue in that case was that the shares were trading at 29 shillings and threepence. If my lords wish to look at it in the original report, it's
Yes, volume 7, I think.
yes. What had happened was that the shares were trading at 29 shillings and threepence. And that was the price at which the Crown compulsorily purchased the shares. However, it went to arbitration. The arbitrator determined that the price of the shares was 41 shillings and 9pence by valuing the company and then dividing it amongst the shareholders. And so in that case, the Crown, because it had acquired 100% of the company, had a huge uplift, which was significantly greater than the value of the shares as trading. And what the shareholders claimed was that it was basically unfair that the Crown should get the whole value. The Crown was saying, well, that's all you had. It's exactly the same issue that we've got in the present case. And the passage of 42, paragraph 42, it said on the one hand that it's the essence of the matter that the Crown is, as it's bound to do, acquiring all the shares of the company. Prima facie, as it seems to us, and apart from any special words in the regulation, each shareholder is entitled to get, and to get only the value of what he possesses, which of course is our argument here. For that is all he has to sell or transfer. If an individual shareholder in a company owns such a number of shares in that company as gives him effective control of the company's affairs, it may well be that the value to be attributed to that holding on a sale of it as a separate transaction is a figure greater than the sum arrived at by multiplying the number of his shares by the market value for the time being of a single share. In such a case, the shareholder in question, it may be said, has and is able to sell something more than a mere parcel of shares, each having the rights as to dividend and otherwise conferred upon it by the company's regulations. In the present case, neither of the claimants has such a holding of shares as confers effective control of the company's affairs. No claim on the part of either is made on that basis. The claim of each is to have added to the value appropriate to his individual parcels of shares, if being sold separately, a rateable proportion of the added or control value belonging to the totality of the shares, an item of value which he as an individual does not in fact possess. Then goes on to the particular figures. We can ourselves see no reason in principle why the first claimant should receive more than the value of what he has. We observe that if some third shareholder in fact held a controlling interest in the company's capital, the effect of the claimant's contention would be to appropriate to their own holdings some part of the control value, which the third shareholder might well allege was an item of value belonging to him. So that's exactly the same here if you adopt the Delaware approach.
But the wording of the regulations was different, wasn't it?
It was.
They were looking for market price.
I accept that entirely, but they consider it from first principles. In other words, all they had was the value of the shares. It was minority shares. What's wrong with that, that price? Because the consequence of that is that you're going to penalise somebody. Why should that? What is fair about penalising somebody with a control premium?
But in this case, if the position is that the two-thirds majority, and I don't know what the voting split actually was.
About 91%.
Okay, the 91% were not an inherently controlling majority. In other words, they were simply a majority because they, all being individually minority shareholders, got together and agreed that this should take place. They wouldn't have in their shares, and if they're on the buyer's side as well, as I understand it, they were in this case,
yes,
they end up being shareholders in the company that becomes the 100% parent of Shanda.
Yes.
So they get, in economic terms,
no.
Well, can I just...
Sorry, yes.
They are at any rate rather like the government on the buyer's side in the short case. But they would, if the dissenters are valued at a minority, pick up, if you like, the difference between the, let's say, 9% value of the undertaking by virtue of a minority discount being applied in the valuation, because they would be shareholders in the buyer, which is going to be the 100% parent.
Well, I deal with that at paragraph
Like
76 and 77 of the case, which is at 2074 to 2075. Maybe I can just explain it all why that doesn't work. Because assume you've got 10 shareholders. They're all minority shareholders, therefore the value of their shares are all at a discount to the pro rata value. If 9 of them merge the company, so thereby they acquire compulsory 10, if number 10 gets the equivalent of a minority discount, what the other 9 have got, yes, they've got the total control, but they're still minority shareholders. So the value of their minority shareholder will only have increased proportionally from the value of the Mr. Number 10. So just assume the company's worth £100. and the discount is 50%, so that each of them has £5. I'm not sure I can necessarily do this mathematically, but I don't think I've picked the right figures. But if you take away Mr. 10, so that you've now got the 9, their increase should be equal to the total value of the minority discount of Mr. 10.
Because they all remain.
Because they all remain minority
of
shareholders.
UK,
Yes.
in this context, where the company is being interposed.
So one mustn't always think that that the surviving shareholders have somehow benefited disproportionately from the merger. It may be if they are the majority and they have a control premium, but they've paid for that control premium.
Well,
So-
this is a take-private transaction, i.e. to remove control from the shareholders who bought their shares in a market to a smaller group. So there must necessarily be a crystallization of control and ownership in a smaller group.
In that example,
In this
yes.
instance.
I think the point what I'm trying to make is that nobody has suggested that you have that the fair value, the principles on which you calculate the fair value can differ depending on the particular facts of the merger. So you don't say, well, in this particular merger, somebody else is getting a significant benefit. Therefore, what you've got to do is to try to work out the price that would have been paid by the minority to the majority if they'd actually negotiated it together.
But we're talking about people who are giving up shares in one of the constituents of the merger. So that company is going to be taken under the wing of another company and may not survive at all.
It may not survive.
So it's being, as it were, taken as a totality, as a package of one entity.
In a particular situation, yes. If it's the surviving company, no.
In the case you've just taken us to, the whole argument between Sir David Maxwell Fyfe on the one side and Sir Cyril Radcliffe on the other was that one was saying, in reality, what's being acquired here is a totality of a company. And the other one was saying, well, under the regulations, what's being acquired are a lot of individual shareholdings. Yes. And on the regulations, Sir Cyril Radcliffe prevailed.
Yes. Yes. But what they point out are the inherent problems in giving a straight value for all the shareholders in one class. Because you penalise some and you'll...
But you're making the assumption that the premium is something which the majority are entitled to.
Well, so why not?
Well, the legislature is entitled to say it belongs to everybody.
Of course they are, and the question is whether that's what they've done here.
Indeed, I agree.
Can I just ask you what I asked Mr. Crowe, which is, fair values sounds in some minds like fairness between somebody and somebody else. I don't suppose it can be any doubt that on one side of the scales we have the dissenter, or each dissenter viewed separately if it matters. Do you challenge the concept? And if you don't challenge the concept, who's on the other side in this case?
Well, we deal with valuation terminology, and it might be useful just to go to this at this point. We deal with it at page 31, which is 2085 of the record. And we've taken it from the International Valuation Standards of 2007 because it usefully discusses the different types of valuation. And in essence, you seem to have three different types of valuation that they discuss. One is, in one form or another, what is the actual value that the person has, so that what would be the price that they could sell it for to an independent third party. The IVS defines that as market value, but of course the International Financial Reporting Standards defines that as fair value. So if you look at the top of page 32, the term fair value is the price that would be received to sell an asset or paid to transfer a liability in an orderly transaction between market participants at the measure date. So I'd be very careful about saying, well, we think this is what fair value means, because it's used in different contexts to mean different things. But certainly, the framers of the IFRS see no difficulty in describing fair value as meaning what in other contexts might be described as market value.
That's for the purpose of recording an item in your financial statements.
Exactly, yes.
Yes. It's not a court measure. It's not a measure applied by the court as fair value.
In what context?
Well, it's not intended to be. This is not a statement of what fair value is for the purposes of Section 238.
No, it's not.
No.
But that's what the issue we have to decide is, what does fair value mean? And what I say is, don't start from the proposition that because the term fair value has been used, it means something different than market value, or what in other contexts would be market value. And we've set out in the case, it would be surprising if they'd used market value, because some of the shares may not have had a market. They may not even have been transferable. They may not be transferable for some time in the future. And similarly, at the time of the merger, if there are publicly traded shares, they will be affected by the merger offer. So we say that that's not the correct way to value the shares. You value the shares on the basis of the value they would have had if no merger had taken place. So what we're saying is, it's nothing surprising that one hasn't found the word market share. And I'll deal with the Chicago and Munns case, which my old friend referred to as the starting case in the Delaware authorities. So anyway, that's one basis of valuation.
But market value must mean a negotiated value, something that would be negotiated between willing buyer and willing seller.
Well, that's why fair value. Yes, but of course, what if an asset can't be sold? There may be restrictions on selling shares. It may be that you only get the shares once you've worked for the company for 3 years, or you can only realize them for 3 years. So that's why I say you have to determine what's the fair value of those shares, not what could they be sold for, because they may never be sellable. So I don't find any difficulty with having the word fair value, and therefore I suggest I would submit we don't start on the basis that must mean something different to market value. It may be, but nevertheless, it may not. It's what is fair. And then I think, and paragraph 110 is the point that my Lord Briggs is referring to, which is what the IVS calls the equitable.
Yes.
Which is what would be the price that would be negotiated by two individuals. And of course, the classic example they give, which is at 112 of the case on page 2087, one of the examples they give of equitable value, the determination of a price that is equitable for a shareholding in a non-quoted business, where the holdings of two specific parties may mean that the price that is equitable between them is different from the price that might be obtainable in the market. And so in that situation, if you had a 60% shareholder and a 40% shareholder, and the shares were being sold by the 40% shareholder, the 60% shareholder, you may well get a price negotiated between them, which would be less than 40% of the proportionate value of the company, but more than the price that the 40% shareholder might have got from a third party, because the 40% shareholder has the prospect of getting a higher sum of money. The 60% shareholder has the prospect of getting 100% control and an uplift. So one would expect them to negotiate a price somewhere in between. That's what I think is equitable value. And then, just to go through the IVS, one then, paragraph 114 of the case, they then refer, of course, to the American context. Many national, state, and local agencies use fair value as the basis of value in a legal context. The definitions can vary significantly and may be the result of legislative action or those established by courts in prior cases. They then give examples of US and Canadian definitions of fair value. And the first one is the Model Business Corporation Act. And what one finds in those states that have enacted that legislation is a specific statutory section which expressly removes the discounting for lack of marketability. So what they say is immediately before the effectuation of the corporate action to which the shareholder objects, using customary and current valuation concepts and techniques generally employed for similar businesses in the context of the transaction requiring appraisal, and then 3, without discounting for lack of marketability or minority status, the value of the shares. So one gets there a statutory enactment of what the Delaware judges have interpreted their provisions to mean. And ultimately, it's going to come down to what does this provision mean? Of course, the legislation can enact something like this, perfectly entitled to do so. What we say is this isn't what applying our principles of statutory interpretation lead to in respect of 238. And that's the narrow issue that this case is all about. But I think to take my Lord Briggs's point, nobody has suggested in any of these cases that one values the shares on the basis of an equitable value. In other words, that one looks at who is acquiring these shares.
Well, it might not be who's acquiring. I was wondering about the statutory context is a disagreement between the shareholders of one of the companies involved in the merger about whether that company should or shouldn't participate in one way or another, and there are all sorts of different ways in the merger. Yes. And a resolution of that disagreement in favour of a 2/3 majority, but with a right of a minority then to be taken out and paid fair value. And if it does mean fair value as between parties, it might incorporate some concept of equitable value, because that's the only one of the various labels in your very helpful table which appears to look at it in those relativistic terms.
Well, that's a possibility, but the consequence of that would mean that you would look at what value each of the other shareholders had as a result of that transaction, so that you potentially would get a different conclusion where the requisite majority were all minority shareholders, or where it was effectively they would be acquiring.
But in this case, the happening to which these shareholders object, as I understand it, is this company becoming owned by a single parent company. In other words, it is a situation where that to which they object is a 100% ownership outcome by a separate third party, albeit that the 2/3 majority look as if they will control it.
That is right, although I'm not sure I've got the facts at the tip of my fingertips, but it's actually a group of buyers, I think, rather than one buyer that's dealing with it. Certainly, that as a factual inquiry never took place at first instance. There were just two options, which was you value the company and you then come up with a proportion of shares, or you apply a minority discount. Unless there are any questions following from that last topic, this is probably...
Well, in that case, we'll look forward to hearing you further at 2:00.